Smithtown Planning Board is now in session. Would you join us in the Pledge of Allegiance, please? Jim?
Pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
We thank you. Please.
Good evening, Mr. Chairman and members of the board. The first item on the agenda, the Planning Department recommends the following items for adjournment as we have insufficient information to act upon them. Part 2, Item 2, number 2011-01, All Seasons Motor Lodge. Item 3, number 2010-06, KVC Holdings. Item 4, number 2009-05, FB4 Realty. Part 3, Item 9, number 1098, Parnell Estates. Item 10, number 922, Sesame Estates. Item 11, number 1053A, Berg Estates. Item 12, number 911A, Glen Hill Northern. Part 5, Item 14, the 288 application of Olivia Estates. Mr. Chairman, these are the items the Planning Department recommends for adjournment.
Thank you. Is there anybody here to be heard on those items to be adjourned? Hearing none, a motion.
Mr. Chairman, I'd like to make a motion to adjourn the item read.
Second.
All those in favor?
Aye.
Opposed? So ordered.
Mr. Chairman, the next item on the agenda under Part 1, Item 1, is the letter of interpretation for Brent J. LLC. This application was brought before the board at the last planning board meeting on August 17th and was adjourned pending an on-site inspection. I believe that all of the board members have completed their on-site inspection, and if you're ready to proceed, I believe the applicant is ready to make a presentation to the board.
Good evening, Mr. Chairman. J. Timothy Shea, Jr., Sir Tillman Ballin for the applicant, Brent J. Not going to make a very long presentation. I think we vetted most of the issues the last time. I would just note for the board's record that after the hearing, we had an opportunity to sit down with the neighbors who had testified at the last hearing. Based upon those conversations, it's my understanding that they are in support of our application for the letter of interpretation. And furthermore, that one of the items that I think the chairman raised with regard to fencing was brought up to the neighbors, and they did not want to see any fencing placed on that property. I would just note for the record that the title to that property, even though it will be sanitized, as in it will not be able to be developed, shall remain with the landowner, and he does have an ongoing obligation to make sure that his property stays clean and is maintained. And that would be the end of my presentation, and I would hope that the board would pass the letter of interpretation as outlined by the Planning Department and as applied for by the applicant.
I just had one question. On the Overton Pass frontage, there was a piece left out to go with the main property of 46 foot. Any reason there? Is that because of the private entrance there that there's an easement and you're just trying to protect there the entrance to the back of the property if you have to, or?
Well, I believe that the design was arrived at in order to meet the yield that we required, and that after we met the yield, meaning the 3 credits or the 60,000 square feet, and we felt that that was the best way to design it. I don't think that there was any other rationale
behind it. In other words, the 46 foot was left out of the frontage on Overton.
Yes,
And as far as I can see, that if they had closed it all off there and made it there for drainage or something, then there would be no question in the future there that somebody was going to do something there. But looking at the map, I thought, well, maybe because of the easement on Nanny's Way into the front of the property, that maybe they were retaining that opening back there in case that easement was not available to them in the future.
if I may have 1 second to take a look at the
Okay.
survey.
this was considered the frontage at one time. That was the reason he did that.
Okay. The owner of the property has indicated he thought that the surveyor did that to maintain frontage on Overton. I don't know why he would have felt obligated to do that, but I think really the main thrust here was to create 2 lots for transfer that would total 60,000 square feet and would also meet the other zoning requirements. We had to square it off so as you had adequate depth and adequate width under the zoning codes, which is required in order to effectuate the transfer.
But there was no other intention there other than that?
No, there was no other intention than that.
Okay. Because if people were concerned that there was going to be nothing built in that whole strip, if somebody had to put a driveway in there, I wouldn't want to have them tell them that we didn't know they were going to put a driveway in.
I don't think that
Okay.
the current owner certainly has no designs on putting any driveways in
Okay.
there, and I don't think it really lends itself to that. If you notice the steep slope, to
Yep.
put a driveway in, I think would be unduly expensive.
Well, it would be a tougher job going to find a driveway in there to go up there to the house, that's for sure.
Correct.
Any other questions by the board?
Mr. Shea, it's my understanding that you're going to have to file a covenant with the county clerk in connection with this application.
Yes.
Can you give us an idea of how long that takes to file it with the county clerk?
Well, fortunately, the review of this covenant will be going to the town and not the county health department, so I think it'll be a little bit quicker than it would be otherwise. I would think that after a decision is made, probably 2 to 3 weeks.
2 to 3
And we
weeks.
do intend on vigorously going forward with our application to effectuate the transfer. We have a tenant in waiting, ready to go. So
Would you-
we're going to move with all due haste.
These applications are somewhat new to us, and I think there's a concern that we want to keep track of these covenants somehow, make sure that they're filed properly. Would you have any objection in providing us with proof, not with a personal appearance or anything, could be done by correspondence, when it's filed, that you provide us with that proof?
I think the normal procedure when you get a grant from a planning board, whether it be this board or any other board, is that you would record the covenants, you'd have the covenants reviewed by the planning department and the law department, make sure that they are legally sufficient, record them, then send them back. But I will be happy to send a courtesy copy to the chairman so that he is aware of it when we come back, we hope.
Okay.
And your time frame that we're looking at is, you mentioned 3 weeks, or?
We have to order title, we have to draft the covenant, we have to get a copy of the decision, assuming we get a grant here today. So I would say 2 to 3 weeks. And then it has to obviously be reviewed by the planning department and probably your law department to make sure that they are satisfied with the covenant.
So if we calendared this not for a personal appearance I don't want to make your client incur any costs unnecessarily, but if we calendared this for 2 months, just to get that proof back that the covenant was filed properly, would that be sufficient in your eyes?
If I may,
Sure.
I think procedurally, and I hope I'm not being presumptuous, the next step would require us to come back to this board to effectuate the transfer of development rights. We couldn't do that until the covenant is recorded. We intend on making immediate application, assuming a grant of our application is done here tonight. I wouldn't want to have to calendar something out for 2 months and then have our application pending during that period of time. As I indicated, we do have a tenant in waiting. I will tell the board this, that when we come in for the actual transfer of development rights, we're going to have to present this board with the actual covenant
Okay.
in order for you to effectuate that transfer. So I don't necessarily think that calendaring it out for 2 months is going to serve any real purpose here. We would have to have it recorded and have it back to present to this board in order to effectuate that transfer. So I think we're probably going to be way in front of that.
Okay.
At least that's our goal.
But when you file it, you will send a courtesy copy to the chairman?
Oh, certainly.
Okay.
This is not what we're doing now, because of the newness of these applications, is trying to establish a format that we can follow as we go along on these applications. And one of the questions that came up was the covenant. So that's the reason that Mr. Oshman asked the question, and why we wanted just trying to find a timeline when we could expect the covenant to be in place.
I would say that there'd be a good chance that it'll be in place within 2 to 3 weeks. Before we're back here on the TDR,
Yes,
assuming
okay.
again the grant. I don't want to
Okay.
assume anything.
Thank
All
you.
right. Okay. Any other questions by members there at the audience on this application? All right.
Mr. Chairman, do you want us to read the resolution into the record?
Well, you want to make a motion on this, right?
Right.
Huh?
I'll read it into the record.
Okay.
After reviewing the documents submitted with the application, the Planning Department recommends that the Planning Board issue a letter of interpretation indicating that there are 3 rights available on the identified portions of the subject parcel, and offers the following resolution for the Board's consideration. Be it resolved that the Planning Board hereby issues a letter of interpretation that the Board has determined the number of density flow rights available on the subject parcel, Suffolk County Tax Map Number 37-2-16.4, to be 3. Mr. Chairman, that is the Planning Department's recommendation for the LOI-4 application for Brent J. LLC.
We thank you. A motion?
In the matter of LOI-4 Brent J. LLC, motion to issue a letter of interpretation determining the number of density flow rights available on the subject parcel, 37-2-16.4, to be 3.
Second.
All those in favor?
Aye.
Opposed? So ordered. Thank you very much. We thank you. Yes, you too.
Mr. Chairman, the next item on the agenda, under Part 3, Item 5, Number 293, Kingsbury Lawns. The applicant requests a waiver to amend the original conditions of approval in order to maintain several accessory structures within a 15-foot screen planting area within the subdivision known as Kingsbury Lawns, Number 293. The map of Kingsbury Lawns, Number 293, was granted conditional final approval from the board on April 21st, 1965. This application was approved for a 16-lot subdivision fronting on Old Comac Road and 2 proposed cul-de-sacs to be known as Taffy Court and Johnson Avenue. At the time of approval, conditions were placed on the final map regarding the screen planting area. Specifically, Condition F states, indication on the map of a 15-foot screen planting area along the rear of lots numbered 1 through 4 and along the northerly side yards of lots numbered 4, 5, 13, and 14. The screen planting area was made a condition for this subdivision to maintain a buffer between the residential property and the commercially zoned property immediately to the west and the Long Island Railroad tracks immediately to the north of the site. In the mid-1980s, on the town board's own motion, the parcel immediately to the west, Suffolk County Tax Map Number 24-3-2.1, was rezoned from light industrial to R10, single-family residential, 10,000 square feet minimum. The applicant is requesting the waiver in order to maintain 2 sheds and a carport that were constructed in the planting area to the north along the Long Island Railroad right-of-way and a swimming pool that was constructed in the planting area to the west. It should be noted that 2 prior applications have been brought before the board for other lots in this subdivision for waivers of the planting area. The board conditionally approved the request from the owner of lot number 14 to waive the condition of the planting area to the north along the Long Island Railroad right-of-way on April 19, 2000, and for the owner of Lot Number 2 to waive the condition for the planting area to the west of the formerly zoned LI property on September 19, 2007. The engineering and traffic safety departments have no objection to the waiver request. The Highway Department, in their August 12, 2011 memorandum, objects to the waiver request, stating that we feel this buffer acts as a noise barrier from the Long Island Railroad. The Planning Department does not object to the applicant's request to waive the requirement of the screen planting area to the west, since the adjacent property is no longer zoned or used commercially. However, the planting area to the north along the Long Island Railroad right-of-way should be preserved to act as a buffer for the residents living along the railroad tracks. The Planning Department recommends the board make this application of an on-site inspection. Mr. Chairman, this is the Planning Department's recommendation for Kingsbury Lawns, number 293.
Thank you. Anyone here representing the applicant? You come to the microphone and give your name and address, please. Mhm. Okay. Okay.
Official authorization for Janet to speak on behalf of the applicant. Just want the board to know.
Okay. Name and address, please.
Janet Haberly, care of Suffolk Paralegal Services, St. James, New York, here on behalf of the owners, Andrew and Alice de Blasi.
Okay.
All right, good evening, Mr. Chairman, members of the board. As has been discussed by the Planning Department, we're here this evening for two requests of waivers. The property is zoned R10. The overall lot is 10,055 square feet, just 55 square feet over the minimum required. If you deduct the square footage of the limited access area for both the north and the west, that totals 2,955 square feet. If you debit that from the square footage of the entire lot, that leaves us with about 7,100 square feet, which is almost 300 less than what the minimum is required for R10. The owners purchased the property in 1993, unaware of the two limited access areas. As Blaise said, the subdivision was approved in '65. The house was CO'd in '66. The western buffer, again, was created when that property was zoned light industrial. That is no longer valid. So we feel that since that has changed to R10 in the 1980s, that the buffer is really, should be rescinded. It really isn't pertinent anymore, since now that property has been changed to R10, and therefore no buffer is needed between the two R10 zones. The applicant is going for the approval of existing carport and two sheds in that northern buffer zone that borders the railroad. Part of that carport and shed also infringe on the western boundary of limited access. The pool and deck only are on that western side. The northern buffer, I have to say, I have been at that house many times, and when the trains go through, it is totally deafening. I don't see, truthfully, how a couple of trees can help abate that noise. I do think that having the sheds there not only visually conceal the trains going by, but act as some kind of noise abatement for the sound of the trains. It really, it's quite deafening, and I grew up in Nassau County and Floral Park with the railroad going by all the time, so I know what I'm talking about. I have submitted photos, 8 photos of properties, not only the subject property, but of properties down the block and on the other side of the railroad, showing that just about everybody has put either a pool, a deck, a shed. The adjacent property that is being developed now, directly adjacent to the west, has 200 feet of 6-foot stockade fence right in the buffer zone. I'm not saying that all these are legal. I have no idea whether they are or not. But everybody's been trying to do something to try to have some kind of noise abatement from the railroad. I'd like to emphasize to the board the unique situation of this lot. Not only is it oddly shaped, it's the smallest lot of the 4 that are on South Johnson Avenue. It is the only lot, being at the dead end of the street, is the only lot that has both of these limited access buffers, both from the north and the west. The ones on Johnson Avenue further south only have the buffer for the western part that was determined, when it was light industrial. But this particular parcel, not only smaller, but also has that limited access from both the west and the north. It's difficult for them to try to have any kind of accessory structures with these limitations on both sides. They have 3 children. They converted their garage to a den. 1 shed holds all the usual stuff all of us Long Islanders have, lawnmowers, summer furniture, et cetera, and the other one is all the stuff that all of our children have, all their paraphernalia. The carport is used because Mr. de Blasi has a classic car and he keeps it under that carport. I would like to also say that it is, again, the smallest lot of those 4. So it has even more of a stringent buildable area than any of the other 3 that are to the south of that parcel. So in summary, what I would like to say is that Planning Department already recommends that the western buffer be removed. Obviously, we're only concerned with our client, his portion of it, but I do believe that it's only fair to everybody that's on that western side. But as far as the northern buffer by the railroad track, we are not asking for that buffer to be removed or waived for everyone because obviously it's there for a reason. What we are asking and requesting from the board is that they allow the existing structures to remain there as they are within that limited access buffer. And I think that the photos that I've submitted to both the Planning Department at the time of the application, plus the additional photos that I've just given to the chairman, show that that area is needed to have the accessory structures that they have presently on the property. Thank you.
You're welcome. Is there anybody here that wishes to speak on this application? Members of the board, any questions?
When were these structures erected? The carport, the sheds, the pool, and did your clients own the home when they were erected prior to?
They purchased in 1993. The sheds and the carport were erected in, the first shed was in 1999, the second shed was in 2002, along with the carport in 2002.
And the pool?
And the pool and the deck were in 2004.
And how did they come to learn about this restriction?
Well, when they approached me to handle this application for them, they knew that they would need variances, and we got a new survey. And when we got the new survey, it showed the limited access. That was their first acknowledgement that they had these stringencies on their property. They were not aware of that when they purchased the property.
But how did they know they needed to make an application? Is what-
To the,
Yeah, how did they know that they needed to come before this board for anything?
because when I filed with the zoning board, which that case is on October 25th, when I filed with them, the survey, the new survey that we had from Hillebrand Land Surveying had the land limited access of planting on both the western and the northern parcel. That's how they found out about it. They were not aware of it before that. They knew they needed variances for these structures, but they did not know about the necessity of coming before the board, hence our application for a waiver.
Thank you.
You're welcome.
You understand we're going to do an on-site?
I'm sorry?
We're going to do an on-site inspection, and
Yes, sir. That's fine.
then we'll come back there and,
Okay,
okay?
thank you.
Any other questions? A motion?
Mr. Chairman, I'd like to make a motion in regards to Kingsbury Lawns, number 293, that we do an on-site inspection of the mentioned property.
Second.
All those in favor?
Aye.
Opposed? So ordered. We thank you.
Consideration. Good night.
Mr. Chairman, the next item on the agenda under Part 3, Item 6, number 876, Wynwood Meadows. Mr. Chairman, this application was brought before the board at the last Planning Board meeting on August 17th and was adjourned pending an on-site inspection. Additionally, at the time of the public hearing, one of the applicant's neighbors did address the board regarding some issues with complaints that had been filed with the town prior to the application coming before the board. I wanted the board to be aware that planning did contact the building department and the public safety department to learn of any complaints that were on file. According to the building department, there are no official complaints on file with them. According to the public safety department, the only complaint they have on record is for the fence, which is what the applicant came before the board to have approved for the waiver. I assume that all of the board members did do the on-site and it's complete. And we do have a recommendation, if you want us to read it into the record, unless, of course, the applicant has anything they want to mention beforehand.
Is there anybody here representing the applicant?
Mr. Chairman, good evening. My name is Doug Hines, HYNES, Design Development Group. We presented our case at the last hearing. I was under the impression that the record had been closed at that time, subject only to the on-site. We have nothing to add to the record. Thank you.
Any questions by the board? None? A motion there for an easement and a covenant.
In the matter of Wynwood Meadows, number 876, I move that we adopt the resolution as read in accordance with the recommendation of the Planning Department.
Second.
All those in favor?
Aye.
Opposed? So ordered.
John.
Oh, did you want to speak? I saw I just asked. I'm sorry. Okay.
Hi, my name is Joseph Barak, B-A-R-R-A-C-O. I live right next door, 4 Wynwood Drive, Wisconsin. I'd like to know what the story is about the PVC fence at the corner, about the light, because very dense, like I said last time, it's very dense. And that's my opinion, okay? Because happened to me, almost I was killed but because the fence, the tree on the corner, especially there's one tree the town put it, okay, right on the corner on the curve, okay. From Wynwood, if you come in on my street from Wynwood, okay, you gotta be on Nicholas Road to see the traffic, okay, and that's danger, personally, okay, because I try and like I said last time, it's a lot of accident. So I say, if it is any possible, okay, to bring the fence down, okay? I don't say I don't want this, no fence, but limit this to 4 feet, okay? Let's have it 4 feet to see the street when you get on the corner. That's why I'm asking. The law, there's a law. That's part of the law, especially on the corner on Business Street.
Well, what we did an on-site.
Okay,
Everybody went out there and looked at it.
okay.
And I could hardly see the top of the fence from the road. I could hardly see it. So that I think that was one of the reasons why everybody was satisfied that a covenant to correct the easement, the conservation easement, would be a way there to make sure that nothing more was ever done with that property from the standpoint there of being able there to protect the rights there of the covenant.
So otherwise, the way it is now, that's supposed to be?
But we do that, we try to be good neighbors if we can.
I try to, I try to be.
And if there was something really offensive, if we found there that the fence was offensive, then we probably would have there considered something. But everybody looked at it and felt that it was a reasonable way to correct the situation there was with a covenant on the easement in order there to make sure that nothing went any further than that, okay?
So otherwise, we can do nothing about it.
It's not a question you can't do anything
mean-
about it. We question that we do this all the time. We try to accommodate as neighbors there to people to make sure that it's not offensive to the people there that are going by or anything like that to see a fence there from the road. You can hardly see that fence from the road.
Because like I said, there's a trees. Otherwise, there's a tree in the front of the fence. Okay, that's why I say.
We try to respect an honest mistake, okay? We don't try there to make it tough for people there when they've made an honest mistake.
About a light, about a light right in the corner. At least there's something to go, to stop, because a lot of people, they don't stop. There's a stop sign there, but a lot of people, especially on Nichols Road, they run in the curve. Okay, there'll be a lot of accident there. If you put a light, at least they come down, so, little slow on Nichols Road, and the people got a chance to go a little forward, to make a left turn.
Mr. Chairman, if I could add one item. I was just speaking with Blaze. There is a sight distance problem with the trees, some of the trees and shrubs in that particular area, but those are actually on town-owned property. And it's not the applicant's property. What I'm going to do is I'm going to forward a request to the highway superintendent to examine that intersection, maybe trim back the trees so that there will be some improvement in sight distance in that particular area. But Blaze went out to the site, and basically I was asking him about the sight distance, and it's mostly due to shrubs and brush that are on the town-owned property, not within the right-of-way. So,
But would that be consistent with the original conservation easement?
yes, it would be, but
Okay.
what
All
we're
right,
trying to
well-
do is, what he's complaining about is sight distance, and I think if we trimmed some of the trees, I'm not saying cut the trees down, I'm talking about trimming some of the shrubs back, it might improve the sight distance. Well, if that's highway's job to do anyways in the right-of-way, so we're going to ask him to take a look at it. Okay?
Those, like you say, okay, there's tree on the corner, okay? Those tree is the town, like you said, the town properties, okay? And those tree there, okay, it's got to move it inside his property. And then maybe there's more room to look, to go, okay? It's a lot of, I wish that somebody come there and I to explain on the site, to what the real story is.
Mr. DeRubis is going to have the highway department send somebody out there to see there if there's anything there that could be corrected, okay?
I appreciate it.
Okay.
That, I mean, we know we got rural regulation, okay? I mean, this man, okay, I plain English if I hope. This man, since he moved there, he make some problem the fourth day, okay, the fourth day. And until now, I got 5 permits.
You're
Because
right next door to him, sir?
oh, excuse me?
You're right next door to him.
Yes, right, yes.
Is your house for sale?
Well, I'll be honest with you, I don't want to sell,
sir,
but
sir.
this man making me so
Sir,
aggravated.
sir, you're the house right next door, correct?
Yeah, right.
I believe when I did the on-site, I think I saw, was that your house that's for sale right next door?
This
Okay.
moment, yes,
Thank
but
you.
I don't know when.
But no,
If I get my money, I sell.
Fine, I just wanted to know, sir,
Yes.
if that was your house
Yes.
next door. and
Right.
So there was a for sale sign on your property?
Right.
All right, thank you.
That's because I get aggravation. I got 5 permits for this man.
We're
Thank
going to
you.
have somebody come out to the property and look at the road and see if there's anything there, and I'll make sure there that he'll contact you to talk to you, all right?
I appreciate. I'm home all day.
Okay.
It's not. I mean, probably I'm in and out, but I'm home 99%. I'm home.
Okay.
So otherwise, they don't get no.
You live right next door, and we'll contact the highway department, have somebody come to you next door,
Okay.
okay?
Okay. Thank you very much.
Okay. All right. The next item.
Mr. Chairman, the next item on the agenda under Part 3, excuse me, Item 7, number 1112, Keshet Estates. Mr. Chairman, this application was brought before the board at the last Planning Board meeting on August 17th. The board adjourned that matter for an on-site inspection, and I believe that the members of the board have completed their inspection, and we have a resolution to read onto the record if you'd like. The Planning Department offers the following resolution for the board's consideration. Be it resolved that the Planning Board hereby approves the request of William Bylot to waive the requirement of installing 280 linear feet of sidewalk along Sunken Meadow Road within the subdivision known as Keshet Estates number 1112. Mr. Chairman, this is the Planning Department's recommendation for Keshet Estates number 1112.
Anyone here representing the applicant? If you come up and give your name and address, please.
Bill Bylot, 15 Woodmere Drive, Fort Salonga. Last name spelling's B-Y-L-L-O-T-T.
Okay, you understand there what we're going to do there, waive it?
Yes.
Okay. Is there anybody in the audience that wishes to talk on this? Any questions from the board? A motion for a waiver.
In the matter of Keshet Estates, number 1112, move that we adopt the resolution as read in accordance with the recommendation of the Planning Department.
Second.
All those in favor?
Aye.
Opposed? So ordered.
Thank you.
Mr. Chairman, the next item on the agenda under Part 3, Item 8, number 1062 Mill Run Estates. Mr. Chairman, this application was brought before the board at the last Planning Board meeting on August 17th. At that time, it was adjourned by the board pending an on-site inspection. I do believe that all of the board members have completed their inspection. Additionally, I just wanted the board to be aware that within your packet, attached behind the memorandum for this application, is a letter from the applicant stating that he and I spoke regarding the performance bond with respect to the waiver of sidewalks along Harnett Road and New Highway, and he does agree with planning's request regarding making a contribution to the town's street tree and sidewalk fund, which is part of the resolution that I am about to read. The Planning Department offers the following resolution for the board's consideration. Be it resolved that the Planning Board hereby approves the request of James Fuller of All Island Purchase to waive the requirement of installing 771 linear feet of sidewalk along Donna Court, but denies the request to waive the installation of 450 linear feet of sidewalk along Harnett Road and 416 feet of sidewalk along New Highway. In lieu of constructing the sidewalks on Harnett Road and New Highway, the board will accept a contribution of $4,000 from the applicant to the town's street tree and sidewalk fund for future sidewalk construction at these locations. Mr. Chairman, this is the Planning Department's recommendation for Mill Run Estates number 1062.
Thank you.
That's me, just
Okay.
in time.
All right. Name and address, please.
James Fuller, 10 Winmar Way, Center Reach, New York.
Any other questions you have?
No, that's fine. That's acceptable to me.
Anyone here from the audience that wishes to speak on this? Members of the board? Any questions? A motion for the waiver.
In the matter of Mill Run Estates, number 1062, motion to adopt the resolution as read in accordance with the recommendations of the Planning Department.
Second.
All those in favor?
Aye.
Opposed? So ordered.
Thank you.
Mr. Chairman, the next item on the agenda under Part 4, Item 13, number TC11-01, T-Mobile Northeast LLC. Mr. Chairman, this application was brought before the board at the March 2nd, 2011 Planning Board meeting, at which time it was adjourned pending a secret recommendation from the Department of Environment and Waterways. Additionally, at that meeting, some of the residents that lived behind the CVS shopping center in question had some concerns regarding lighting, which the board did request that the applicant take care of, prior to coming back before the board for an approval. The applicant did have the lighting situation corrected, and I believe that they supplied the board with copies of nighttime photos, which showed that the lights were no longer an issue for the residents. At this time, we do have a secret recommendation from DEW, and if the board wishes, I can read it into the record. The following resolution is recommended for the special exception petition number TC11-01, T-Mobile Northeast LLC from the Department of Environment and Waterways pursuant to the State Environmental Quality Review Act. Be it resolved that the Planning Board of the Town of Smithtown hereby declares itself lead agency on this matter and finds that this matter is subject to the State Environmental Quality Review Act and is classified as an unlisted action pursuant to SECRA. And be it resolved that the Planning Board of the Town of Smithtown does hereby issue a secret negative declaration, determination of non-significance, and EIS is not necessary in the matter of the special exception petition number TC11-01 by T-Mobile Northeast LLC for the following reasons. A, the proposal does not appear to significantly threaten any unique or highly valuable environmental or cultural resources as identified in or regulated by the Environmental Conservation Law of the State of New York or the Smithtown Town Code. B, the proposal does not involve the physical modification of or construction upon lands which suffer from any severe environmental development constraints, no high groundwater, no poor soil properties, and no unmanageable slopes. C, the proposal appears to be consistent with the planned use of the parcel and compatible with neighboring land uses. D, the concealment of the personal wireless telecommunications antennas and related equipment within a proposed structure that simulates a chimney and rooftop bulkhead minimizes the visual impact of the proposed project to the surrounding area. And E, the proposal appears to be consistent with the location, site, design, and safety requirements of Chapter 242 of the Smithtown Town Code. The Planning Department recommends approval of this application and offers the following resolution for the board's consideration. Be it resolved that the Planning Board hereby approves the application of T-Mobile Northeast LLC, special exception petition number TC11-01, for a personal wireless service facility pursuant to Chapters 242 and 322-30.3 of the Town Code, subject to the following condition. 1. Appropriate signage shall be installed at all access points to the roof that provides the following information. A. Notification that a telecommunications facility which produces radio frequency emissions is present on the roof. B. Identification of the radio frequency emissions range. And C. Provision of contact information to arrange for shutoff of the facility in the event it is necessary for any person or people to be on the roof. Mr. Chairman, this is the Planning Department's recommendation for the special exception petition number TC11-01, T-Mobile Northeast LLC.
Is there anyone here representing the applicant?
My name is Jennifer Doherty. I'm an attorney with Phillips Lytle. I'm here on behalf of T-Mobile Northeast LLC, and I also have David Duras with me from Civil Solutions Incorporated. We have D-O-U-G-H-E-R-T-Y.
Okay, anything to add to the,
We have no additional comments. We work very closely with the department to address any of the concerns. We think this is going to be a great facility. It's as 8-panel antennas. It's behind a stealth, and it's behind a stealth enclosure, so it will cause little to no visual impact.
okay? Is there anyone in the audience that wishes to be heard on this application? Members of the board? A motion for the secret negative on T-Mobile.
In the matter of the special exception petition number TC11-01 by T-Mobile Northeast LLC, motion to approve the secret negative declaration.
Second.
All those in favor?
Aye.
Opposed? So ordered. A motion there on the application.
In the matter of T-Mobile Northeast LLC, special exception petition number TC11-01, motion to adopt the resolution as read in accordance with the conditions recommended by the Planning Department.
Second.
All those in favor?
Aye.
Opposed? So ordered. You're welcome. Anybody else wish to have anything there before the board? The gentleman in the back? Nope. Okay. Just a discussion there on these TDRs. We'd like to stay on top of the covenants in a manner that we know when they're going to come in, if we can.
We just had a conversation this afternoon, not with regard to anything that the board brought up with, but the covenants are actually covenants on behalf of the county, which we're going to be reviewing. And what they have asked us to do, and we have some other issues with regard to that, is we're going to be keeping a listing for the county, which is going to be simultaneously in both the health department and our department, as well as the building department, so that they are in all of the appropriate agencies as to where there are covenants on them. So we will have an official listing of these covenants that we maintain in 3 departments in the town, so that we will have them. But they will be, the covenants will be county covenants, and they'll be enforced by the county. But for our purposes, by the way, that's given to the building department, they can't issue a building permit on it or do anything in those particular areas. So there'll be notification on that particular regard. But if there's a violation, like somebody goes into the properties or whatever, we could report them, but the county will enforce them.
And the other issue was the on-sites. We would like to make sure that we have the time to look at these properties as they come forward, because they're all going to be different types of applications.
If I understand correctly, I was out last week, Blaze informed me, what you want is the recommendation at the second meeting, not the first meeting.
Okay.
And that's, we'll do that.
Okay.
Okay?
Any other questions by the board? A motion to adjourn?
Motion to adjourn.
Second.
All those in favor?
Aye.
Opposed? So ordered.